Well, that was anticlimactic. Hello, everyone. My name is Kurt Mueller. I am your favorite patent attorney, and we were here today with what was supposed to be the blockbuster case of this Supreme Court term, but it was a fizzle. Masterpiece Cakeshop versus Colorado Civil Rights Commission. Let's cut to the chase. Nothing interesting happened in this case. It has no precedential value for any future case. It doesn't tell us anything about what the law is. It disposes of this case and this case only without any guiding effect towards the future. So, unfortunately, it doesn't tell us anything that we want to know, but let's cover the facts and cover what the Supreme Court did tell us and try to extract some meaning from this decision. So, on screen right now, I have some examples of past cakes from Masterpiece Cake. These are all cakes that the cake maker, Jack Phillips, made in previous weddings. So these are examples of his work. And Masterpiece Cake, in the form of Jack Phillips, argued that these cakes displayed a level of artistry and a level of design that expressed speech, that there was expression in a speech-related context that gave him a right to create or not to create based on his own desires. As is often said, you can't make an artist create. But the people that were involved in this case thought that perhaps he could be forced to create, because he would and has made many wedding cakes, as you can see here, for straight couples in the past. So, can he be forced to make a cake for a gay couple? Of interest, at the time that this issue came around in 2012, gay marriage was not legal in Colorado. Gay marriage would not become legalized until several years later. But there was a law that prohibited discrimination on the basis of sexual orientation by businesses otherwise open to the public, of which Masterpiece Cakeshop was one. So the question was, this general law that said you couldn't discriminate, was there any defense that could be offered? Was there a First Amendment interest in the cakes and in the designs of the cakes to the extent that the law that was a general law would not extend to this specific example regarding artistry? The Supreme Court decided not to answer that question. They ruled instead under the Colorado Civil Rights Commission that ruled the case initially was biased in its findings. Turning to the key part of the opinion of the court, the Justice Kennedy, in his majority opinion, looked to a statement made by the commission in July 2014 as the commission was making its initial findings as to whether or not there was or was not a violation of the law. One commissioner said, quote, "I would also like to reiterate what we said in the hearing or the last meeting. Freedom of religion and religion has been used to justify all kinds of discrimination throughout history, whether it be slavery, whether it be the Holocaust, whether it be, we can list hundreds of situations where freedom of religion has been used to justify discrimination. And to me, it's one of the most despicable pieces of rhetoric that people can use, to use their religion to hurt others." Justice Kennedy found that this statement went too far. It represented what he considered to be animus by the commissioner and the commission as a whole with respect to one's religious beliefs. Justice Kennedy went on to write, "To describe a man's faith as one of the most despicable pieces of rhetoric that people can use is to disparage his religion in at least two distinct ways, by describing it as despicable and also by characterizing it as mere rhetoric, something insubstantial and even insincere." The commissioner went even so far to compare Phillips' invocation of his sincerely held religious belief to defenses of slavery and the Holocaust. That sentiment is inappropriate for a commission charged with a solemn responsibility of fair and neutral enforcement of Colorado's anti-discrimination law, a law that protects discrimination on the basis of religion as well as sexual orientation. Justice Kennedy relied heavily on that particular statement from that commissioner, as well as a prior statement from another commissioner at a prior hearing, which on its own face might have been ambiguous, but Justice Kennedy felt in context of this much more direct statement was in fact representative animus by the commission with respect to religion. Okay, that's all fair and well and good. We should have people who are fair and reasonable and apply the law neutrally. I don't have any problem with that. I don't think anyone else does. So perhaps the commission was biased. The problem is, what are they supposed to do about it? Let's suppose that this situation appears again. Perhaps Masterpiece Cake will open its doors once again to having cakes made by the general public. If that happens and another gay couple walks in and they're denied again, what is a future commission to do? Let's suppose we can get a group of people together who are neutral and fair and treat religion with respect. Respect that the Supreme Court says was not afforded in this particular case. What are they to do? Well, the Supreme Court doesn't tell us. The Supreme Court only says the outcome of cases like this and other circumstances must await further elaboration in the courts, all in the context of recognizing when these disputes must be resolved with tolerance, without undue disrespect to sincerely held religious beliefs, and without subjugating gay persons to indignities when they seek goods and services in the open market. Fellow lawful masses, I have very little trouble believing that the Colorado Commission was in fact biased in its process. My only question, and the question that's completely unanswered here, is did that bias actually make a difference in the result, in terms of a meaningful difference in the result? If the commission had been unbiased, what result were they supposed to reach? The United States Supreme Court doesn't say here. They merely say that it must await further elaboration in the courts. So I don't know what a Civil Rights Commission in Colorado or any other state is supposed to do in these circumstances. There is just simply no clear guidance at hand. Well, my friends, that is it. It is a short decision. It has no precedential effect whatsoever. Everything in here is dicta that doesn't apply to this particular case. This case resolves one situation with one cake maker, and that's it. We know that Jack Phillips isn't guilty of the law as far as the United States Supreme Court has been concerned, because they have reversed this. They didn't remand it. It's over for Jack Phillips. But the United States Supreme Court has provided us no meaningful guidance going forward as to what speech is in the context of cakes or other wedding-related businesses that might come into play, and has provided us no indication of how this will be adjudicated in the future. So this is neither a good day nor a bad day for the LGBT community. The case basically has no effect. The law is exactly as it was before. So if a gay couple walks into a cake shop and wants to make a cake, can the cake maker say no? I don't know. The United States Supreme Court didn't tell us. So sorry if you were looking for something more meaningful. I was, but the United States Supreme Court didn't tell us anything. That's it. Until later, my friends, my name is Kurt Mueller. I am your favorite patent attorney, and I hope you're well. Until later, my friends. Cheers. Bye.